Hello, everyone, and welcome to Uncivil Law. For today's case, we have a story of a woman who was arrested for drunk driving but blew a 0 on the breathalyzer and was kept in jail for 8 hours anyway. This is the case of Sana Barrett versus Sarah MacArthur. In this case, the police arrested a woman because they thought that she was driving under the influence, but they were unable to find what she was under the influence of. No drugs, no booze, but they kept her in jail for 8 hours anyway. Is that a constitutional violation? Let's get started with this. On March the 24th of 2014, Miss Barnett went out to dinner with her friend in downtown Orlando. After dinner, they walked around the area. At the end of the evening, Miss Barnett drove from a friend's home from downtown Orlando back to Seminole County in her friend's car. On the drive home at around 3:25 in the morning, Miss Barnett stopped for around 8 to 10 seconds at a green light because she didn't know where she was going. It was an unfamiliar area, so she couldn't figure out where she was going. So she's stopping at a green light. But a police officer, saw this. So after stopping at the green light, Deputy MacArthur activated the in-car video and followed Miss Barnett for a short distance before initiating a traffic stop. According to the deputy, she observed Miss Barnett driving about 10 miles under the speed limit, 35 and a 45, drifting from left to right within her lane and varying speed between 35 and 40. Miss Barnett disputes that she was driving erratically. She contends the video shows no perceptible drifting in her lane and does not show her varying her speed other than when she slowed down to the left. For the purposes of our discussion, we accept Mrs. Barnett's version of events. So, we are here on a qualified immunity challenge, as I'm sure you expected. The district court, of course, granted qualified immunity, so we don't have a finding of fact. So what the video shows or what other things show, we don't know, but we will just assume that Miss Barnett, all the facts are in her favor. It's because if she doesn't win under that, she can't win under anything. So we will assume that she wasn't, in fact, driving erratically, and we will press on with our analysis to figure out whether or not there's a qualified immunity thing or not. When the deputy approached the car and spoke to Miss Barnett, she asked for a driver's license, registration, and proof of insurance. Miss Barnett provided her driver's license, but according to the deputy, she needed to be reminded to give her registration and proof of insurance. She attempted to open her glove compartment to retrieve the documents, but fumbled with the button and was unable to open. The parties dispute as to whether the eyes were glassy or bloodshot, so again, taking the facts most favorable to the non-moving party, we assume that they are not. Deputy MacArthur then asked Miss Barnett if she had been drinking, and she responded that she had had a glass of wine at around 6 p.m. that evening, which at this point was 9 hours ago in time. After that, Deputy MacArthur asked if she was willing to participate in a field sobriety test. Miss Barnett agreed, but she did not know what the exercise would entail. Deputy MacArthur proceeded to conduct a horizontal and vertical gaze evaluation, a walk and turn exercise, a one-legged stand, a finger-to-nose test, and a number-counting exercise. Upon realizing what the test involved, Miss Barnett repeatedly told the deputy that her performance could be affected by injuries she sustained in an automobile accident, including muscle tears in her leg, for which she was going to physical therapy. This was Deputy MacArthur's first or second time making a DUI arrest, so she's a relatively new police officer trying to do this, so, not going super great. And the parties dispute whether she explained, administered, or interpreted the results of the test properly. Why she just didn't do a breathalyzer, I don't know. The parties also dispute how well Miss Barnett performed on the field sobriety test, some of which occurred outside the view of the dashboard video camera. Deputy MacArthur claims she witnessed multiple indicators of impairment, while Miss Barnett denies there were any such. Again, we accept the factual indicators. So yeah, as to what was factually true or not, again, we assume this from Miss Barnett's point of view, but this is a new officer. This is her first or second DUI stop. They're not quite sure if this is her first or second one, though. But either way, it's relatively new. And, whether or not this officer is able to figure out whether or not she's drunk or not, yeah. I don't know why she just doesn't give her a breathalyzer, but we're doing the old school field sobriety. Maybe she doesn't have one. I don't know, but whatever. That's what's going on. All right, so let's press on. At her deposition, the deputy testified that there were no indicators that she had been using drugs. She did not observe any evidence of drugs, find any drugs in her purse, or smell marijuana in her car. Miss Barnett, moreover, did not slur or speak in a manner that suggested that she was impaired. Indeed, the deputy testified that she did not have probable cause to believe that they were under the influence of any drugs. When Miss Barnett arrived at the jail, the breath test operator observed her for 20 minutes, I'm not sure why, and then conducted breathalyzer testing. Miss Barnett provided 2 breath samples, both of which registered 0.000 for alcohol. Zero trace. None at all. Okay. Mr. Bentham testified at deposition that after observing Miss Barnett, he did not see any signs that she was impaired by drugs. He nevertheless obtained a urine sample by request. The urine test came back around 4 weeks later, confirming they didn't have any drugs in the system. So, yeah, this woman is arrested for DUI. I'm not sure why they didn't have a breathalyzer test on the field, but when they came back to the one at the precinct, which typically is much more accurate, then that one registered flat 0. No alcohol at all. So, probably not a DUI, whatever else it might be, yeah. Even though the breathalyzer test established that they were not intoxicated or, had any alcohol in her system of any variety, she was nevertheless required to remain in jail for 8 hours from the time of her arrest pursuant to a policy of the Seminole County Sheriff's Office. So Seminole County, Florida over here says, we're going to hold you in jail for 8 hours no matter what. Okay. Mr. Bentham testified under this policy, even if the breathalyzer tests are 0.000, and even if there's no indication that they're under the influence of drugs, they still must wait 8 hours from the time of the arrest, even if they postpone. So we didn't have any proof that you were in drugs or alcohol. We didn't find any drugs. We didn't find alcohol. We didn't find anything that you're smoking. We know that you don't have any alcohol, and you still have to remain in jail 8 hours anyway. Why? I don't know. Seminole County just wants you to be their friend, I guess. Shane Love, the captain of operations at the jail, confirmed in the deposition that this is, in fact, the policy of the Seminole County office. This is what they do. They detain arrestees for at least 8 hours, even if the breathalyzer test is 0.000. Deputy MacArthur testifies once she arrested Miss Barnett, she was going to have to stay in jail for 8 hours pursuant to the policy. Fine. Okay, so that brings us to where we are now. We are trying to get at the county or city government for policy. So this is slightly different than a qualified immunity analysis. We're here under what we call a Monell claim. We've discussed this before. We are going after not the officers in this case for their particular actions, but rather for the unconstitutional policies of the city, state, city, or county government. So we are going after them for the Monell claim for the violation of the policy. What would be the policy? We're going to hold you in jail for 8 hours no matter what. That seems like a problem. So let's try and figure out whether or not we got a Monell claim. Miss Barnett challenges the district court grant of summary judgment in favor of the sheriff for their claim under Monell. She argues that she was unlawfully detained pursuant to the whole policy, which violates the Fourth Amendment because it requires continued detention even where there is no probable cause for continuing detention. Seems like it might be a problem. The detention claim against the sheriff in his official capacity is, in fact, a claim against the county. Fair enough. A municipality can be sued directly under 1983 when one of its customs, practices, or policy causes a constitutional injury. So if the officer does something bad to you, that's a qualified immunity issue in 1983. If the county does something bad to you from policy, then that's a Monell claim. That's what we're trying to do. Probable cause exists when an arrest is objectively reasonable based on the totality of the circumstances. This standard is met when the facts and circumstances within the knowledge of which he or she has reasonably trustworthy information will cause a prudent person to believe, under the circumstances shown, the suspect has committed, or is about to commit an offense. But probable cause to make the initial arrest is not the end of the issue, because detention in jail is a type of seizure for which Fourth Amendment attacks. So even though we might have had cause to arrest, whether or not we can continue to detain you is also a seizure of your person, because of course it is. It is undisputed that the sheriff's whole policy mandates an 8-hour detention of a person like Miss Barnett, who is charged with a DUI, even if the breathalyzer test shows an alcohol content is 0.000, and even if she posts bond. The summary judgment evidence in the district court makes this clear, and the sheriff concedes the point in the brief. In granting summary judgment in favor of the sheriff, the district court reasoned the whole policy is consistent with the federal law, with the Florida law, which allows the option of holding a person for at least 8 hours. So the district court said this is authorized by the law. The district court can't read, apparently. This is error for two reasons. First, Unlike the hold policy, the law does not require an 8-hour detention of all DUI arrests. You can't read law, district court. Try harder. Second, even if it did, the statute could be unconstitutional as applied. So here is the language of the hold policy that the district court apparently cannot read, because they say the law requires you to hold them for 8 hours. Let's see if you can spot the problem that the Florida District Court apparently didn't spot because they don't know how to read. So here is the statute as it's written. A person who's arrested for a violation of a DUI may not be released from custody until the person is no longer under the influence of alcoholic beverages, any chemical substance set forth in law, or any substance controlled under law, and affect to the extent that his or her neural faculties are impaired, until the person's blood alcohol level or breath alcohol level is less than 0.005, or until 8 hours have been elapsed from the time the person has arrest. It's one of them. Any one of them would be fine. Yeah, it doesn't require you to hold them into 8 hours. No. So, as we have explained, the law simply requires one of the 3 conditions to be met to ensure sobriety prior to release, one of which would be an 8-hour lapse from the time of the arrest, and one of which would be a blood alcohol level of 0.005, incidentally, which she meant at least 2 of 5. 2 of them, so you got that going for you. On this record, Ms. Barnett's detention claim against the sheriff must be decided by a jury. Viewing the evidence in the light most favorable to her, Ms. Barnett was kept in custody pursuant to and because of the mandatory 8-hour hold policy after 2 breathalyzer tests registered blood alcohol levels of 0.000 and after she posted bond. The only remaining question is whether a reasonable jury could find the hold policy as applied to her violated her rights. I'm sure she'll have fun with that. Following a warrantless DUI arrest based on probable cause, officers do not have an affirmative duty to investigate or continually reassess whether an arrestee is or remains intoxicated while in custody. But where the officers obtain information which shows a reasonable doubt the arrestee is not intoxicated, in other words, that probable cause does not exist, the Fourth Amendment does require the person to be released. So you don't necessarily have to continuously reevaluate, but if new information comes to your attention, you can't detain them anymore. The Sixth Circuit has rejected the argument that where subsequent developments disprove the correctness of the previous determination that probable cause exists, the police no longer have jurisdiction under the Fourth Amendment to continue the suspect and release the suspect. So the Sixth Circuit doesn't think that police have a duty to release you if they come into information that that the probable cause no longer exists. Apparently, the Sixth Circuit has no problem with this, but of course, Florida's not in the Sixth Circuit, so they disagree. The Sixth Circuit incorrectly suggested there are no cases or authorities supporting the Fourth Amendment position it rejected. So the Sixth Circuit also doesn't know how to law. When the Sixth Circuit decided its case, the Fifth and Seventh Circuits had already held under the Fourth Amendment a person must be released from custody if probable cause existed for that had dissipated. And then for some reason, the Sixth Circuit doesn't know how to law because it didn't acknowledge, consider, or discuss those discussions either. The Second Circuit was concerned that investigators would have an affirmative duty to reevaluate the matter of probable cause with every new piece of information or evidence they received, which incidentally, I don't even see the problem with that. Why shouldn't you reevaluate probable cause with every new piece of information or evidence? I mean, it's not like you have to do something formal. It's kind of it's just the back of the envelope mental math. But do you still have probable cause or not? If you come into new evidence, why shouldn't you reconsider whether or not that changes the analysis? It might not in a lot of cases, but why is it that much a deal to spend 1 second thinking, does this change the probable cause analysis? The Sixth Circuit thought this was a major problem for some reason. I'm not sure why. The Fourth Amendment standard we announced, however, does not place on police officers an affirmative and independent duty to further investigate in order to continually reassess the matter of probable cause in a warrantless arrest case. It only requires that officers release an arrestee if the evidence they obtain demonstrates beyond a reasonable doubt there's no longer probable cause for the detention. That standard, we believe, properly balances out the competing liberty interests and law enforcement concerns and remains faithful to the Fourth Amendment textual command that seizures and demonstrates be reasonable. One final matter warrants discussion. This is a nice little touch and try from the sheriff, but yeah, this is an interesting one. The sheriff contends he cannot be held liable under Monell because the jury found in favor of the deputy individual Fourth Amendment detention claim against her. As the sheriff sees things, the jury verdict means that there was no Fourth Amendment violation. And without the Fourth Amendment violation, there cannot be liability under Monell. So for whatever reason, the jury did not find liability to the officer. That could be for a whole host of reasons this court is about to explain. But yeah, so the county tries, well, if the officer didn't violate your rights, then it must be that the county didn't violate your rights. And the court is like, no, that's not quite how this works. Just because the officer didn't violate your rights doesn't mean that your policy didn't violate your rights. Those can be different things. This argument is superficially seductive, but on this record, it does not work. It is true, as the sheriff says, that an inquiry into governmental entities' custom or policy is relevant only where deprivation has occurred. But the problem is that the jury's verdict in favor of the deputy does not constitute a finding that Miss Barnett suffered no Fourth Amendment violation as a result of the detention. This is not a controversial concept, as many of our sister circuits have come to the same conclusion. Monell does not require a jury find an individual defendant liable before it can hold the local government liable under 1983. Although the acts and omissions of no one employee may be violating of constitutional rights, the combined acts of several employees acting under governmental policy may nevertheless violate the rights. At trial, there was no evidence that the deputy had any discretion or role in keeping Barnett in custody after arresting her and taking her to jail. Indeed, the captain testified the deputy turned over Miss Barnett over to the staff at jail and confirmed the deputies had no discretion to release the DUI arrestees before 8 hours passed. So the jury found him not guilty, at least in part, it seems, because the deputy apparently had no choice by policy, which brings us exactly to the problem. The policy was bad. Because the jury found only that the deputy had not intentionally committed acts that violated the Fourth Amendment right, not to be arrested or detained without probable cause, its verdict says nothing about whether the continued detention of Miss Barnett after her test and after posting bond due to the sheriff's whole policy violated the Fourth Amendment. Thus, we reverse the district court's grant of summary judgment on Miss Barnett's Fourth Amendment detention claim against the sheriff under Monell and remand for a trial on that claim. In all other respects, we affirm. Thus, that brings us to the end of the case of Sina Barnett and Sarah MacArthur. In this case, Miss Barnett was arrested for a DUI, even though it appears that she had no alcohol in her system and she was not on drugs. So whatever the officer did or did not observe that gave them probable cause, maybe the police officer needs some more training. It sounds like it was only her second DUI. But whenever she got to the station, she blew a 0.00, and then they held her for 8 hours because no one apparently can read a statute. The statute says you can't release until one of three things happens, not until all of them happen. And she did blow less than 0.05, like 0 is less than 0.05. So you could have released her, and evidence to keep her there. So, go back to trial court and find out whether or not you violate her rights or whether a jury thinks so. At least for the moment, that brings us to the end of the discussion of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.